Hi, my name's Alex Monaco, solicitor and head of Monaco Solicitors, specialist employment law solicitors representing employees only. So you may have watched our other video on the meaning of without prejudice, and this is an old-fashioned word that means confidential or off the record. If you're in an employment law dispute with your employer and you want to leave your job with a fair exit package deal, then you could do a lot worse than actually writing to them, setting out your case, what's happened to you, and asking for an amount of money at the end of that letter too. If you want our advice, you should write that as a without prejudice letter. You write the words without prejudice at the top. That's different from a grievance. A grievance letter is quite similar. In the grievance letter, you'd set out your case. You wouldn't ask for money at the bottom. And the main difference is that a grievance would be dealt with in your employer's grievance procedure. So it's kind of an open procedure where there would be an HR there and there would be notes and it would go on your file. Whereas a without prejudice letter would be confidential, off the record, wouldn't go on your HR file, and they couldn't really refer to that in some kind of grievance procedure, and it couldn't even be referred to in any future employment law tribunal. So you've decided to write a without prejudice letter to try and get yourself a fair deal. How do you go about doing that? In practice, you can write an email. It can be in the body of an email, that's fine. It doesn't need to be an attachment, but if you feel like going a bit more formal and a bit more hard-hitting, why not get an attachment there and PDF it, get it spelling and grammar checked properly so that you're not making any silly mistakes in there. It sounds obvious. And then attach it to an email. So within your email, you can say, please see attached without prejudice letter, and you open up the attachment, and there it is, a letter saying, dear sirs, without prejudice, setting out your case, yours faithfully. The first thing you need to do is emphasize how much of a good employee you've been, if you have, with an unblemished track record. Make them sound a little bit good, so bring them up a bit. I've really enjoyed my job. I've worked tirelessly for this company for years. You're setting the scene. Then you can take them down into the mistreatment. Then you start setting out what happened to you. Unfortunately, on such and such a date, and with employment law, remember, it's who said what, when, where, and how. So what's the name of the manager, if it was a manager or a colleague that said or did something to you, when did they do that thing? And how did they do it? Or if you have it in writing, which is good to have evidence in writing, refer to your evidence there in your without prejudice letter. A bit of a chronology, referring to various bits of evidence is your friend. So you're setting the scene there. Then you need to identify how that legally has infringed your rights. So figure out what rights have been infringed. If, for example, it's a discrimination situation, which are very unfortunate cases, you're probably going to refer to the Equality Act 2010. Whereas if it's an unfair dismissal, then you're probably going to refer to the Employment Rights Act 1996. So have a look at our website, some of our videos on YouTube as well. Figure out what has been, what legal rights have been breached. You need to include that. And then finally, the offer itself. So figuring out what to ask for. By and large, you'll be asking for your notice pay. You could be asking for that paid in lieu, which means you don't have to work your notice, but they'll still pay you for it, which is great, right? You don't have to work and you still get paid. Then, of course, any benefits like holiday or bonus, potentially a car allowance, commission. Then it's the termination payment, also known as the ex gratia payment. That is your lump sum payment that you'll be asking for as compensation. That, by and large, that's tax-free up to the first £30,000. Often, depending on the mistreatment you've received, that would be in the region of 3 to 6 months. Frankly, if you can get 3 months in a sort of average case, all cases are different, but that could be considered to be a fair result. If you've been really badly treated, then 6 months would be more like it. If it's a career-ending loss, perhaps you are that bit older, nearing retirement age, or perhaps you've had a psychiatric injury at that point you might be asking for 12 months or even some years of worth of salary as compensation. That's quite a rare case, but that does happen. We see that a lot. If that's you, definitely get a solicitor. Don't try and go into a big negotiation like that on your own. Even if you're more in the sort of average category of the sort of 3 months, then of course, if you get a solicitor to write that without prejudice letter for you, it's going to not only sound better, but you're much more likely to get a better deal, because your employer they'll really sit up and take notice. They'll be a bit shocked when they open that letter or that email from a solicitor's firm, especially if it's, for example, from Monaco solicitors, because they will look us up. They will see that we only represent employees. We don't represent businesses. We're 100% behind every case that we take on for that reason. And they will then have that nagging fear in the back of their mind that we are going to take them to an employment tribunal and win. And that's really the sort of carrot and the stick. So on one hand, the stick is that they think you're going to take them to an employment tribunal. So do be prepared to do that if you have to. On the other hand, the carrot is, no one wants that. You're going to leave quietly. You're going to sign a confidentiality clause. They're just simply, just going to help you do that by tiding you over until you can get another job. So if you have any questions, please feel free to leave a comment under the video on the YouTube channel, or give us a shout through the website, or telephone us to book yourself a consultation. We do offer free consultations in a majority of cases, so please get in touch and have a chat with us today. Thanks a lot.